So would you swap out the trust name on the deed to have it work properly? This comment was posted in a video that I posted regarding the importance of trust funding, which is making sure once your trust is established and signed that you actually move your assets into the trust, which can be done a number of ways. One of them is retitling the asset, where you actually essentially, as this comment is saying, swap out your name, or if it's a joint asset, your name and your spouse's name for the name of the trust. And although we do often see this with real estate, that the property, real estate that's owned by either one person individually or by a married couple, once the trust is created and signed, real estate is then transferred from the name of the individual or the names of the married couple into the name of the trust. And that is one way to do it, and may be fine, and in many states is your only option. However, in states like Florida, where we have a ladybird deed, you have another option, and that option is to keep the property in your name or in you and your spouse's name during your lifetime, and to put the trust on the deed is what they call a remainderment, or it's essentially a beneficiary that goes on the deed. And then the property can be deposited into the trust immediately upon the passing of the owner or the surviving owner, if it's a couple or spouses. There's a couple reasons we recommend ladybird deeds over just transferring the property directly. Oftentimes my clients who have mortgages, I'll suggest it's best just to keep the property in their name, not transferring it into the trust directly. Also with title insurance, which often follows when you have a mortgage, title insurance is a requirement. When you retitle the property into the trust, there is at risk of losing the title insurance on the property. So that's another thing. Also in Florida, there's a lot of our clients who have really good homestead exemptions, and also disabled veterans exemptions for property taxes. Sometimes the disabled veterans exemption is even 100%, meaning they pay no property taxes. And although there is language that you can add to the trust and add to the deed to help ensure that these exemptions, like the homestead credit, the homestead tax exemption, or a disabled vet exemption, stays in place, not all this language has been tested or seen within the courts, so it is still sort of taking a risk if you transfer the property directly into the trust. Now, on the flip side of that, I'll often have clients ask me, what's easier? What has less steps? Well, if you utilize a ladybird deed, meaning you don't swap the names initially, you keep the property in your name and then you list the trust as a remainderment or beneficiary on the deed, that does require the extra step of somebody needing to go to the county, deposit the death certificate so that the county knows that the person who owned the property passed away. And once that information makes its way to the property appraiser site, they can update their documents and make sure that the property switches from the current ownership into the trust. So a little added time. Death certificates are oftentimes filed with the county anyway, especially if there is going to be a probate. So that might not be a big of a deal, but hopefully we're trying to avoid probate. So, we would want to not have to file a death certificate if a probate wasn't needed, of course, and just the extra step of having to make that happen can make it a little more cumbersome. Whereas if the property is owned directly by the trust, exactly what this comment is asking, would you just swap the trust out for the trust name for the individual's name on the deed? If that is the case and the trust fully owns the property, then the trustee can simply make sure that the property gets distributed in accordance with the trust by signing a trustee's deed. So if it's being sold, the trustee can sign whatever paperwork needs to be signed to sell the home directly out of the trust. And if the home is owned by the trust and it's going to an individual, the trustee can sign what's called a trustee's deed to convey the property from the trust to the individual who it's going to. So I guess a little bit of a shortcut there. So you really have to weigh the pros and cons as far as, do you want to put the property into the trust immediately once the trust is formed and signed, and that would be swapping out ownership from the original owner or owners of the property to the trust. Or if you are in a state like Florida, which permits ladybird deeds. Is it better to just keep the property in your name? Is there a reason that you should keep it in your name, a legal reason, rather than transfer it into the trust immediately, but have it instead transferred to the trust upon your passing? So these are really good speaking points to talk to a qualified estate planning attorney about, because everyone's situation is a little different. So you might get different advice depending on what your biggest concerns are or what your specific scenario is. But yes, swapping it out, meaning changing the title from you to the trust once the trust is prepared and signed, is an option to fund the trust for real estate or real property. And either way, something does have to be done. Either the ladybird deed, listing the trust as a beneficiary, or completely swapping out the ownership so it goes from individual or married couple ownership into the trust. One of those two has to happen in order for the real property to make its way into your trust and outside of probate. So I hope this helps. You do have options. What you're stating is one of the options. If there's any other questions regarding real property and trust, or anything to do with estate planning, elder law, or probate, and you're in Florida, don't hesitate to contact our office. We're atCAUSE Law Office, and the link is in my bio.